to be present this afternoon and to present on the CARE program in the Public Defender's Office. It's a pleasure to be here. Along with me is Shalon Joseph, Deputy Public Defender in our office, and also an attorney with our DJJ unit.
And your name and title again?
Winston Peters, Assistant Public Defender in charge of Administration and Special Operations.
Thank you.
Councilman, I'm not sure whether you have one of our handouts, which is the agency report from the Public Defender's Office that pretty much outlines the programs, including the CARE program that I will be referring to.
Thank you.
Should I go ahead?
Please.
Back in 1998-99, our office, the Public Defender's Office here in Los Angeles, had a unique opportunity to apply for a federal grant referred to as the Juvenile Accountability Block Grant. Actually, at the time, it was called the Juvenile Accountability Incentive Block Grant. And with that grant, our office had the opportunity to apply for federal funding that would allow us to provide additional services and treatment for our clients. Mr. Judge, the public defender at the time, made the decision, rather than using the available funding to hire attorneys, he decided that we should instead hire psychiatric social workers. The reason for that was that, as you know, Chairman Cardenas, many of the kids in the juvenile justice system encounter many serious psychosocial problems, including mental illness, substance abuse, co-occurring disorders, and a range of psychosocial issues that needed to be addressed. And since the hiring of psychiatric social workers would give us a unique opportunity to address those issues, Mr. Judge decided to apply for funds so that we could move in that direction to provide a much more holistic model for the children that we represented. And so the first year in 1999, we hired 12 psychiatric social workers, including one supervisor. And we used those social workers to staff each of the 10 juvenile courts in Los Angeles County. In addition, we hired that year 3 resource attorneys who specialize in mental health and educational advocacy, because we were concerned that many of the kids that we represented had additional concerns or problems with the educational system in school. They presented special education problems that had never been diagnosed, and we felt that many of these kids and the families needed to have someone who could direct them through the maze, the bureaucratic maze that was ever present as we tried to get kids back into the school system and getting the treatment and services that they were entitled to under state and federal law. And so our resource attorneys gave us that additional expertise to address those issues. So we started that year with 12 psychiatric social workers and 3 resource attorneys who worked at the front end of the juvenile justice system. So once the kids were arrested, at the point of arrest, and they came into the system and the public defender was appointed, our lawyers would interview the children, and as we spoke to them, we realized that they presented with a range of issues, and we talked to their families that presented with these issues of mental health and substance abuse, etc. Many times they were victims of abuse and trauma. Our social workers our lawyers would ask our social workers to be a part of the team. The social workers would interview our clients, would interview the family members, and would come up with recommendations as to how we could best represent this child holistically before the court, and also to provide the court with additional information about the child and the family so that the court can make a much more informed decision as to what should happen with this particular child on a much more individualized basis. Many times our reports supplemented what the probation report said, and in many cases we provided information, and we continue to provide information maybe the probation officers were not able to obtain. Many times the attorneys are in a unique position as counsel, and many times the children will divulge to us information that they would not readily divulge to maybe a probation officer or to someone else, or maybe to the police. And so in many cases, at the front end, we obtain this information with the assistance of our lawyers, with our social workers, with our resource attorneys, and then we move forward on the case, sharing that information in many cases with the judge, making referrals, doing a range of strategies so that we can provide much more effective and holistic legal representation for our clients.
Now, I have a question. Most Americans would assume that a public defender's role is to act as someone's lawyer, and that's it. What do these kinds of evaluations have to do, psychological evaluations have to do with being someone's lawyer?
Well, I think that it's important that as a lawyer, we define the term lawyer much more broadly.
Now, who's we?
Our office, the Public Defender's Office, in moving particularly in this direction with the acquisition or the funding of social workers and resource attorneys, we made a decision that in many cases our clients presented with these mental health issues, and we're talking about mental illness, mental retardation, issues of competency, developmental disabilities, learning disabilities, emotional disturbances and trauma. We were encountering these issues time and time again on so many cases, and the data both locally and nationally brought out the fact that a very high percentage of our kids, of children in the juvenile justice system, encounter these problems, these psychosocial problems. And so as counsel for these children, we felt that we could not work in a vacuum. We could not just focus only on the legal aspects of the case. We had to address these issues because in many cases, sometimes they were defense to the underlying charge, but more than that, more than just the legal part of the case, we felt that it was our role as counsel to address these issues, because in looking at the entire picture, we felt that to stop these kids from coming back into the system, it made sense to work with other stakeholders in the system, whether it be the Department of Mental Health, whether it be the regional centers or any of the other service providers and stakeholders, to provide treatment and support for these kids so that they would not come back. So we see our role much more expansively, working on the legal aspect, but also providing support, treatment, and services in partnering with other stakeholders in the county to assist our kids.
So your adoption of this responsibility and interpretation is from a fiduciary responsibility or a legal responsibility, or both?
Well, it started as we believed that it was a legal responsibility, but as we speak today, and as a matter of fact, a few years ago, the Judicial Council of California passed what we call Rule of Court 1479, which today is reflected in Rule of Court 5.663, which says that the duty of the responsibility of defense counsel in juvenile cases involves exactly what I've been talking about, a much more holistic approach that looks at all of these additional areas in addition to the legal aspects of the case, because these children present these issues, and the legal case cannot be seen in a vacuum. In order to really effectively represent these children in the juvenile justice system, we cannot ignore these core underlying issues that contribute significantly as to why the kid came into the system in the first place. And if we ignore them, the kids would tend to come back. So we feel that this is a much more effective, cost-effective, and it just makes more sense to address these issues holistically, working with the families, working with other stakeholders to address these underlying issues in addition to the legal aspects of the case.
Now, on a 12-month rolling basis, about how many of these juveniles end up receiving this kind of service? In the handout, it mentions this on page 392 of the handout. We serve approximately 1,200 to 1,500 children every year in the care program at the front end. Now, initially we started with 12 psychiatric social workers, as I indicated, and 3 resource attorneys. Today, we have approximately 20 social workers in our juvenile division and approximately 9 resource attorneys. And I will say that even with this increased numbers from 12 to 20 and from 3 to 9, we are only serving maybe about 8 to 10% of the kids that really need
the assistance, simply because we don't have the resources to really provide these services to all of the kids that we represent. But so we do a sort of a triage in terms of addressing these issues. So 12 to 1,500 kids per year, and since the inception of the program in '99, we have served approximately 12,000 children and counting.
Now, how many children, but if you served every child that came past your way, how many children a year would that be?
I mean, I think that if we had the resources to address all of the kids that presented with a lot of these issues, it could easily double that number. I mean,
Okay, but I want to go one step further. What if you had all the resources you needed so that every child that comes into contact with you, you give them some kind of evaluation or what have you by these professionals, and including the young people that they're fortunate enough to where the professional individual says, this kid doesn't have the psychological issues that need our kind of addressing of those issues. How many young people, all told on a 12-month period, would you be assessing?
I would say probably, I would think at least double or 2.5 times what we're serving now on a, just the ballpark estimate.
So 2,500 to 3,000 a year?
Yes, I think that would be the ballpark that we could be talking about. Perhaps more, but I mean, that's a ballpark.
What other departments at the county level actually come in contact or custody or responsibility of these young people could actually implement this if they found the resources or chose to try to address this as well themselves?
Well, the Los Angeles County Probation Department represents or is in charge of all of the children in the juvenile justice system with their camps and with their probation officers, et cetera. So they have the primary responsibility to take care of these kids, especially when they're detained in the juvenile halls and camps. So they play a key role. They represent all of these kids that we represent. And by the way, the Public Defender's Office represents roughly 50%, maybe 55% of the kids in the juvenile justice system. The other, roughly half of the kids are represented by bar panel attorneys, and at one location by the alternate public defender. I believe that's at either Sylmar or Lancaster. I believe it's in Lancaster. So, yes, so the Los Angeles County Probation Department, and many of these kids are served by the Department of Mental Health, depending on what the issues are, the regional centers. Those are the ones that come to mind off the top of my head.
Okay, thank you.
So, as I indicated, the care program at the predisposition, at the point of arrest, when the kids come into court and the public defender is appointed, our lawyers interview the children. We make an assessment, and in a sort of a triage sort of way, we appoint, we have the assistance of our psychiatric social workers and our resource attorneys assisting our line lawyers in addressing many of the issues that we talked about. I just wanted to mention the fact that the Surgeon General's 2002 report on children's mental health found that approximately 20% of children and adolescents in the general youth population are experiencing a mental disorder. When you consider the youth in the juvenile justice system, based on the reports that are out there, at least 2 to 3 times, there's a 2 to 3 times higher incidence of mental disorders for the kids in the juvenile justice system. In terms of the services that we've provided, I refer you once again to the agency report at page 392. For fiscal year 2007-2008, we served 419 clients through the Department of Mental Health. On average, each child received approximately 6 services. As I said, we provide a range of services that include, and in fiscal year 2007-2008, we provided 7,915 services, which were provided to approximately 1,295 new clients. So that gives you a sort of a range in terms of the types of services that we provide through our resource attorneys and social workers. And that is working in tandem, as I indicated, with other stakeholders such as the Department of Mental Health and providers in the community. We also work very closely with LACO, LA County Office of Education, and LAUSD in terms of getting our kids back in school, working with our parents, making sure that the school districts provide the services that the kids are entitled to under state and federal law. Sometimes these issues involve litigation because there may be an issue, for example, as to whether a child has a developmental disability versus a mental illness, and what, who should be funding those issues. And many times we will subpoena both parties to court and let the judge decide who should be the funding source. So there is an element of litigation in this, but for the most part, we try to bring the parties together and try to access the best services for our clients. I wanted to move on to the other aspect of the CARE program, which is the post-disposition program. Back in 1998, 99, about the same time as we started the CARE program, we started a unique program called the post-disposition program. That was a unique collaboration, probably a unique one of its kind in the country. We actually worked with the probation department. The probation department had a lot of kids in camp who were there for up to 1 year. Could be less time, but up to 1 year. And they told, at the time, the chief probation officer, Paul Higa, the late Paul Higa, who had a lot of vision and foresight, indicated that why don't we, the probation department, partner with the public defender's office to identify kids in the community, kids in the camps who should not be there. Many of these kids had fallen through the cracks and were sent to camp for up to 1 year, and they really were misdiagnosed. They were sitting in camp, they were not getting treatment and services, and they suffered from a range of psychosocial issues.
Now, I have to ask this question. When you say that the kids are in that situation, they're misdiagnosed, other than your, like say in LA County, other than your department, who would take the time to proactively go double check that file so that it can be determined, wait a minute, this kid's been misdiagnosed, we got to do something about it? Who else actually does that?
Well, if the only other parties outside of our office would be the other percentage of kids that are represented by the bar panel lawyers, since they represent, as I indicated, approximately 45 to 50% of the kids in the delinquency system.
So what do they do?
They would have the same charge and legal responsibility as we do.
Are they doing it?
Well, I think that they lack a lot of the resources that we do at this point. But I think that, as in all things, some of these kids are diagnosed and others are not.
But are they able to be proactive like you are?
At the expense of tooting our own horn, I think that we are in a uniquely positioned to identify these issues because of the resources that we have. Unfortunately, they don't. And
So they would probably have to garner some kind of grant, or in the funding cycles within the county, they would have to be given resources for them to exercise the same what you're explaining to us.
Exactly. So, for example, in this post-disposition program that I'm talking about, where we partnered with the probation department to actually we hired back in '99 4 psychiatric social workers, 3 of which actually went into the camps to interview kids that should not be there. And I'll give you a cross-section of the kids that we're talking about. These are children with apparent or suspected learning or developmental disabilities whose special needs could not be accommodated in a juvenile camp setting. These were children with mental health issues, including the need for psychotropic medication, children whose age and level of maturity were not compatible with the camp population or programming, children with physical disabilities that prevented their full participation in camp programs, and children who were about to emancipate from the camp. They were approximately 17 and a half, and had no visible means of support once they were released from camp. The bar panel lawyers do not have the resources to go into the camps as we did back in Still today, they don't unless they receive special funding through the courts, which usually is not.
So what you're describing, correct me if I'm wrong, you have a responsibility to do this work on behalf of the individuals that you represent,
That
right?
is our interpretation of the
Okay.
statutes, yes.
But so that means the bar panel lawyers, they have the same responsibility, but the fact that they're not provided with resources, they're not exercising that responsibility?
They lack the resources that we have based
So
on.
therefore, what happens to their clients?
So therefore, their clients, for example, the bar panel lawyers are not able to go into the camps and represent the kids the cross-section of children that I just mentioned.
So if child X and Z, if child X happens to get a public defender and child Z happens to get a bar panel lawyer, child X is going to have a pretty good chance that they're going to get this evaluation and follow-up, but child Z is not going to get that evaluation and follow-up that you're aware of.
That I'm aware of, simply because the bar panel lawyers as a group are not in the camps, and we are representing our clients in post disposition, as an example.
But at step one, both the public defender lawyer and the bar panel lawyer have the same fiduciary and legal responsibilities to their client.
Our interpretation of Rule 5.663 of the Rules of Court indicate that we do have a broad responsibility to represent both the legal, as I indicated, and the holistic needs of these kids. That has been our interpretation, and we have received support from the presiding judge of the juvenile court. That is our interpretation. That is not that.
But the judge didn't mandate that all children get this same level of service?
The presiding judge has indicated that all lawyers have a responsibility to do exactly what we've been doing, but I'm told that it's always a matter of resources in terms of the resources that the bar panel would need to do what we are doing. We're doing it because of grants and because of our interpretation of the law. I'm told that they lack the resources, and
So how did it come about that this judge gave that opinion? Was it over a lawsuit, or was it just in a particular case and he spewed that out and the public defender's office said, cool, we like his interpretation because we're with that and we've got the resources, so we're going to try our best to adhere to that?
Well, actually, before we started doing this sort of holistic legal representation way before the rule of law, the rule was passed, because we felt this was the correct thing to do. Michael Judge believed that this was the direction to go. And it was only years later that the rule passed, which confirmed everything that we had been doing.
Yeah, but what good is a rule if the same people who have the same responsibility to that category of clients, that because you're a public defender, you're actually applying yourself as best you can to that responsibility to that client, but if you happen to be a bar panel lawyer, you don't?
Well, I agree that it is problematic.
So I'm not a lawyer, you are. What can society, or let's narrow it down to this society of the County of Los Angeles, what can the Society of Los Angeles do, the County of Los Angeles do, to make sure that all of these children have access to this kind of service?
Well, I think it's...
That the courts are saying they should be getting, right?
Right. Well,
Does the ACLU have to bring a lawsuit or something?
Well, I would hope that would not...
I'm not saying that your answer would say that they should. All I'm saying is, what is the remedy for equal representation and follow-up, if whether it's like in my example, child X versus child Z?
Right. I think that, and by the way, I wanted to also indicate that not all public defender offices in the state of California do the kind of holistic representation.
How many do it?
That we do.
One
Maybe
public defender's office? San Francisco?
Maybe
Santa Clara?
San Bernardino.
San Bernardino.
So there may be 2 or 3 others that to some degree do this sort of holistic representation.
Sacramento.
Maybe Sacramento, 2 or 3, but for the most part, most offices around the state do not do the sort of holistic model that I've been talking about. So in answer to your question of what should be done, ideally, there should be more resources out there for public defender offices and bar panel attorneys to do this sort of representation, because I think it is cost effective, it makes sense.
So it's not mandated?
It's a rule of court. We believe that it is required, but there are some interpretations, some offices that do not interpret it that expansively, and different boards of supervisors around the state look at it differently. And also, there's a budgetary issue that.
I contend that it's more budgetary than anything else.
Right. So, I can't really speak about the other counties, but certainly in answer to your question, what is needed is more resources so that attorneys, bar panel attorneys, public defender offices would have adequate resources to provide this level of legal representation for youth in the juvenile justice system. I hope that answers your question.
Yeah.
In the post-disposition program in the camps, since the inception of the program in 1999 through June of 2008, we have handled approximately 1,162 cases. It's a small program relatively. We've had 3 psychiatric social workers working in the camps. They interview the clients that present these psychosocial issues. They talk with the families. They come up with a plan as to what should happen. And the probation department and us then go back to court and say, Judge, you sent this child to camp. Maybe at the time that you sent the child to camp, you did not realize that they presented these issues, these mental health issues. They sort of fell through the cracks. We have a plan. The probation department and us have agreed. Will you now change your mind, change the plan, have this child go back into the community, still being held accountable, still under probation, but getting treatment and services that they're not currently receiving in the camps? Will you do that? And I'm happy to say that since the inception of the program, in 97% of the cases, and we've handled over 1,000 cases, the judges around Los Angeles County have agreed with us, agreed with our recommendation, and have removed these troubled kids from the camp setting, placed them back into the community where they're now getting treatment and services they weren't getting before. So that is the post-disposition program that is in the camp. It's a unique program. As I said, I think it's the first of its kind in the United States. We're really successful with the outcomes, and we have been getting.
Where's the funding coming from in this fiscal year? The fiscal year that we're in right now.
The funding initially was under the TANF grant, and that was for several years. And then because of the success of the program, the county started underwriting of funding the entire program because of the success and the positive outcomes that we have realized.
So as far as you can tell, the Board of Supervisors of the County of Los Angeles have bought into this and have made sure that the funding is there to your department.
Correct, for this program, yes. Now, I also indicated that under the post-disposition program, we have 4 social workers. 3 are working in the camps. One of the social workers is working in the juvenile mental health court at Eastlake. There we have the juvenile mental health court addresses the needs of the most seriously mentally ill kids in Los Angeles County. They present a range of issues, mental health issues, schizophrenia, just all levels of psychosis, etc. The most seriously mentally ill kids. And we, at any given time, we have approximately 50, 55 kids of our clients in that court. And it's a unique collaboration with our office, the district attorney's office, obviously the courts. Judge Christina Hill runs the court at Eastlake. Department of Mental Health, I believe there's a representative from UCLA, a psychologist, and they provide, and LACO, and they address the needs of these kids in the best way possible by, it's analogous to a drug court where all of the parties work together. We suspend our traditional roles and we try to do what's best for this troubled youth in terms of finding treatment and services in the community and or in the juvenile halls while they're there. This program initially started, Mr. Chairman, with funding under the Schiff Cardenas bill. I do remember many years ago that a delegation from Los Angeles actually went to Sacramento when you were in the legislature up there, and actually I have fond memories of actually visiting your office
and others up there to talk about the importance of the juvenile mental health court, and asking for support and funding for that program. That was approximately, I think, if I'm not mistaken, about
9 years ago.
9 years ago, because it once again, it was approximately 99, 2000, somewhere in that range.
Yeah, 2000.
In that time zone. So I was privileged to be a part of the discussions about the juvenile mental health court. We were successful in getting funding under your bill, and that bill helped to fund our psychiatric social worker in the juvenile mental health court, together with an experienced attorney who works collaboratively with all the other stakeholders to address the needs of these kids. And once again, that is also a very successful program.
Now, I want to help clarify for those people listening to this committee, what's the difference between what the public defender's office does when it comes to juveniles and, for example, the city attorney? A lot of people assume that city attorneys, they handle misdemeanors and the DA handles felonies, et cetera. But when it comes to juveniles, isn't it even categorically a whole different situation as to what the city attorney's office is involved with juveniles and versus what the public defender's office is involved when it comes to juveniles?
Well, in juvenile court, it's all the district attorneys. The city attorneys, I'm sorry, are not involved in the juvenile system.
So city attorneys only deal with adults?
Only with adults. We are primarily focused or work with district attorney's office in all of juvenile. We obviously try to work collaboratively with them as best we can to access and provide treatment and services for these kids. So, under the juvenile mental health court, we're under the Schiff Cardenas funding. We are currently receiving $170,000, our office, and with that, we are funding the lawyer, the experienced lawyer in that court. The psychiatric social worker is funded by the county. Initially, as I indicated, we had a little bit more funding, but it's right now we're just funding the lawyer to the tune of $170,000 per year.
$170,000 from the Schiff Cardenas funding.
That is correct.
Which just got funded to the tune of bouncing around $120 million for the state. And this county of Los Angeles represents about 10 million people. State of California is about 40. So about 25% of the state's population. So we're getting, round off, maybe about $27-28 million to the county of Los Angeles in Schiff Cardenas funding. And you're only getting $170,000?
That is my understanding based on the information that I.
You're not getting $1 million?
No.
You're not getting $500,000?
No, we're receiving $170,000 per year.
And if you're off by a figure, it might be to the nearest 10,000, so.
At most.
Yeah. Anybody from the probation department in the room? How much is the probation department getting from the Schiff Cardenas funding?
Huge.
Anybody have an idea? To the nearest 10 million? All right.
I just wanted to move on to one of our other programs, which is Project Youth Embrace. We, at the Public Defender's Office, have a unique collaboration with the Department of Corrections, Division of Juvenile Justice, and under the Juvenile Challenge Reentry Grant, approximately maybe about a year and a half,
2 years.
2 years ago, we entered into a collaboration where we received, under Youth Embrace, we receive approximately $297,000. And with that, we are representing 100 probation kids, our clients, in the camps, and 200 youth who are in the Division of Juvenile Justice who are incarcerated, but it's a reentry program. So what we've done is that we have lawyers, and we work with prototypes, Homeboy Industries, and parole. And we identify our kids, as I said, 100 probationers, 200 parolees who are about to be released. And we work with these youth while they're in the institution. We talk to them about employment, we talk to them about education. Prototypes talks to them about treatment for their mental illness. And all of these issues are discussed and addressed while they're in the institution under a reentry plan. And then there is follow-up as these youth leave the institutions and return to the communities. Prototypes and Homeboy Industries continue to provide case management support so that there is a transition back into the communities. Once again, it's a unique collaboration. There is.
If a young person is represented by a bar panel lawyer, do they end up getting the services you're just describing right now?
No, these are for public defender clients. So we're talking about 300 youth. The probationers in the camps are all girls, so they're 100 girls, and primarily the youth in the DJJ are males, although there may be some exceptions.
Do you want to explain the conflict?
Maybe I can explain why the public defender's office represents only half of the kids in the system roughly.
No.
And
Excuse me one second.
right. Roughly speaking, we represent half of the kids because many of our clients, when they're arrested with other youth. So let's say our client is arrested with 2 other kids. The public defender's office cannot represent all 3 of those kids. So because there's a conflict of interest, they may be pointing the finger at each other, there might be some other issues. So we can legally only represent 1. So if there are 3, for example, we represent 1, the bar panel lawyer will take 1. If it's in Lancaster, then maybe the alternate public defender will take 1. Or if not, another bar panel lawyer will take.
What happens if it's 10 kids caught together?
Then all the bar panel lawyers would take we would take 1, and the bar panel lawyers will take the other 9.
So the
if it was
conflict
9,
is the fact that you're of the same department. So the conflict is erased when a bar panel lawyer comes from XYZ firm, takes kid number 1, another lawyer from a different firm takes kid number 2.
Correct.
And
Because, they could be pointing the finger at each other, and we don't want to be in a situation
I
where we're
understand.
representing all of them. So that is.
so it's better to get caught one at a time than in bunches.
Correct.
And then you can have access to all of these services potentially, rather than be represented unfortunately by a bar panel lawyer, and all of a sudden, in today's world, the resources aren't there, and therefore this follow-up type service is not granted to those kids.
Correct. And once again, I, for the record, I don't want to be interpreted as painting all of the bar panel lawyers with a broad brush, because.
No, I'm not saying whether they give good representation or not. All I'm saying is, do they get these additional services or not?
Right.
And it sounds like the bar panel lawyer system is not fortified with
Correct.
these kinds of services. There might be a unique firm that might have a particular lawyer or the support of that particular firm, where if you're lucky to get that one lawyer from that one firm, you might get additional help.
Right.
But otherwise, there's no systematic help for the bar panel represented kids as far as you're aware of.
Right. I think that it's a resource issue, and that is a major issue. In Project Youth Embrace also, as in the post-disposition program, many of the kids that we represent were former bar panel lawyers, but, for example, in the post-disposition program, where I said some of the kids fell through the cracks, they may have been formerly bar panel lawyers, but because there's not a continuing conflict, we make an assessment that we're now free to represent them. So sometimes we end up representing kids that we formally conflicted on, but because it's not a continuing conflict, we can now pick up the case. And so in those instances, we are able to represent kids that initially we were not able to.
But it's still a small percentage of the bar panel represented kids.
Yes, it is definitely a smaller percentage. So that is Project Youth Embrace, a unique collaboration once again with the state and local collaboration. And I'm also, as I move on, the other project, the main project that we are involved in is the
the RSVP program, the Retail Skills Vocational Program. Maybe about a year ago, we had discussions with the NAACP, with the National Retail Federation, the probation department, to address the needs of kids in the area of employment. We felt that it was important that kids have jobs, that was a major impediment to success once they came out of the institutions. And so we entered into a unique collaboration with the LA County Probation Department, the Customer Service Learning Center, the National Retail Federation, and the NAACP to provide in-camp retail skills and job training, followed by reentry support and job linkage for transitional youth represented by the public defender. The RSVP program is designed to increase prospects for employment of transitional age youth who are completing a camp commitment by providing those youth with the skills and support they need to overcome systemic hurdles and build positive connections for more successful future. We started the program in Camp Miller, and in Camp Miller we had a training class of approximately, I believe it's 12 to 15 youth for the first class. We partner with also the Western Justice Center, and we have job readiness training, computer skills training, motivational engagement, conflict prevention and life skills training, case management, mentoring, and one of the things that we've actually received a grant from, actually based on your advice, Mr. Chairman, and encouragement, we did receive funding from the county through Supervisor Burke's office, and we did receive from her office $142,460 for a 2-year pilot. And with that, we are actually in Camp Miller, providing the training and support in terms of in the whole area of job training and employment. We also have a social worker that is assigned to that project, and that social worker works in tandem with the probation department to provide case management support. Especially once the kids come out of the camp, we want to make sure that we follow up and continue to provide positive reinforcement for these kids. Part of the funding includes computers, so that the kids in the camps each has their own laptop computers. They're working on their resumes. They are looking at the jobs that are available. They're actually taking a retail skills course, and when they pass that course, they actually get a certificate from the National Retail Federation. And we have negotiated with the National Retail Federation that at least all of the kids get at least 2 job interviews once they're released from the camp. They're given bus tokens, and they're actually given, we have a separate fund for clothing, so that they can be appropriately dressed if they don't have the clothing, so that they can attend job interviews well clothed and prepared with their resumes in hand. So once again, this is a unique collaboration. If you were to tell me maybe 9-10 years ago that the Public Defender's Office would be engaged in these kinds of activities, these kinds of outreach efforts, going beyond the traditional legal model,
very little bit.
I would say that would be far-fetched, but here we are, and we're doing these kinds of collaborations with a lot of the different parties and stakeholders in the community, and we're really excited about our efforts, and we really appreciate your support and the opportunity to be here today to share this information with you.
Again, I'm not a lawyer, but you are, so can you please remind me whether or not in this country we still have a unique difference between the court system that addresses juveniles versus the court system that addresses adults? What's the fundamental difference that we supposedly in this country have put on our shoulders between adults and juveniles? Isn't rehabilitation something that we have chosen to have 2 different courts, adult court and juvenile court? Isn't the root of it not only rehabilitation, but isn't rehabilitation the root of one of our responsibilities that we've claimed over and over in this country?
Yes, it is. Rehabilitation is key, and I can speak to that issue both as as a lawyer practicing in the front lines for many years, and now I'm an executive manager, so I see both perspectives. And having worked at Kenyon Juvenile Justice Center in South Central Los Angeles for at least a year and a half as a trial lawyer, I can tell you that what I saw back then, and I still see now, is that we are criminalizing the youth of today too much, and we're emphasizing suppression,
Punishment, suppression.
and punishment much more than we are rehabilitation and treatment and wraparound services. Many of these kids that I've interviewed, and I'm talking about also that our office interviews through our social workers and our line lawyers, many of these kids have troubled past. Many of them are coming from the dependency system. At least 30% of the kids that we represent in the juvenile justice system have some kind of dependency background. They have been themselves the victims of abuse and trauma, which is documented. And many times one of the things that we do is that in representing youth that comes from that background, we actually go to the dependency court and pull their records. And we actually literally go through the files and see the history of this child. And it's really shocking that when you see where these children come from, the troubled backgrounds, and we're talking kids that are 10, 11, 12, and it just goes all the way up. We must not forget these kids. We cannot throw them away. We need to emphasize rehabilitation. We need to emphasize treatment. And I think that is why one of the really satisfying things about being a lawyer, because in our office, especially in our juvenile division, is because we have the opportunity now to provide holistic representation, in that I'm looking after the legal interests of that child, but I'm also concerned about employment. I'm concerned about mental treatment. I'm concerned about, the developmentally disabled. I'm concerned about these range of issues. And it's much more satisfying as a lawyer and as a human being and as a citizen when we can provide these services for these kids and work in tandem with all of these different agencies, so that we don't just have the public defender hat, we have the common sense hat. How can we make a difference in the lives of these children? So we need to work much more closely on the issue of rehabilitation. I will say that I am on the Governor's Committee on Juvenile Justice and Delinquency Prevention, and that is one of the areas where the governor, on that committee, we are looking at resources for kids. At the federal level, we're getting federal funds, and the state and the governor has to decide how those funds will be spent. I'm also part of the MacArthur Foundation, the Juvenile Indigent Defense Action Network, and we're looking at, under the MacArthur committee that I'm on, we're looking at raising the level of legal representation for kids in the juvenile justice system. California is one of the representatives that MacArthur has recently selected to be part of a 7-state delegation that is looking at legal representation and how we can provide these kinds of services that I've been talking about. So, we're trying to work on several fronts to provide this sort of holistic representation, but I do agree with you, and that we need to look at rehabilitation a lot more. We need to decriminalize a lot of the things that we're locking kids up for, and just have a whole different way of looking at it. We need a new paradigm, and that is what we have been striving to model.
Well, I want to thank you for responding to the legislation that I wrote, the Shift Cárdenas Act, when it came to juvenile justice. What you described today was exactly why I wrote that legislation. And I'm very, very upset and disappointed that the County of Los Angeles has chosen to only allot $170,000 for this very unique and important work, and then yet allowing the suppression side of the county arms and legs to go ahead and seem to have unfettered access to millions and millions and millions of dollars of the Shift Cárdenas money year after year, and yet they can't find it in their means to be more equitable with the kinds of programs that you're doing right now. I'll tell you what, I don't ever recall the probation department, and even the police department and the sheriff's department ever quoting the amount of money that they're getting and down to the last dollar. I noticed that you said $460,642 or something like that. They always round it off because to them it's just dust. So I just want to say congratulations for doing all of this tremendous, tremendous work with so little. And what's sad is I'm very upset, and I'm wondering what it would take for our county and every county to be forced to provide these services, which I do agree. The way I see the law, again, I'm not a lawyer, but when I look at the Constitution of the United States, the Constitution of the State of California, and I look at the fact and the history of why we created juvenile courts, and instead of putting our juveniles through adult courts, then what you're doing, everything you described today, is mandated. It is required. It is the law. But unfortunately, it's not being mandated because out of all the counties we have in California alone, there's only 3 or 4 counties that are actually practicing some semblance of what you described today. So I'm wondering who the heck is going to step up and sue so that the courts can say, we've said it a long time ago. And then them say, well, then make them do it. Make them do it. Because the Shift Cárdenas funding is there, and that's a perfect resource. So the counties can't even say that they don't even have the resources for it. Because I can promise you, for the last 10 years, the resources have been there. And it's called Shift Cárdenas funding. And it's general fund funding, and grant funds, and things of that nature. But the Shift Cárdenas funding through thick and thin has been funded for 10 years straight now through the state budget. And the County of Los Angeles has been the biggest per capita because it's disseminated on a per capita basis. So the County of Los Angeles has received the biggest amount of money of the Shift Cárdenas in every single year and accumulatively, bar none. And for them to only dedicate $170,000 to what you're doing is just ridiculous. It's criminal. I have a question for you. When it comes to the meetings that you're on the governor's task force, what happens in these meetings? What does the task force discuss or talk about?
Well, the focus usually is on the federal funds that come from Washington under the Title II and Title V funding, and once they come to the states, the allocation of those funds and what sorts of programs that can be developed to address juvenile justice issues in California.
Title II and Title V, the education issues or what?
It includes education, it includes employment, it includes a range of issues.
Rehabilitation,
suppression, etc. And at the table, it's a broad coalition of members that include law enforcement, probation. I'm the only public defender that's on the committee.
So it's weighted heavily on the suppression representation.
Well, I mean, we are trying to be much more broad-based, but I mean we would like to focus, and certainly I and others have tried to change the focus to much more rehabilitation. I think that we're seeing sort of a trend in that area. We're also looking at the area of disproportionate minority contact, and Los Angeles is one of the sites that is funded under that program to address that issue in the juvenile justice system. So we're looking at a range of issues, but once again, it's the funding in the past under the Bush administration. We have seen, as you're well aware, funding substantially decreased. So we're hoping that in the near future we can see a reversal of that, and more funding under the federal funding will be greater and forthcoming to Los Angeles and other counties to address some of the issues that we've been discussing today.
Thank you.
No, I just want to kind of say the same thing. This was very encouraging to hear of the public defenders programs. I think a lot of people don't realize how involved your office is in really the whole child. I think a lot of people just felt you dealt with them as the criminal and defended them, but this is really encouraging. It's looking at, the whole person, and it's interesting that you talked about going back and looking at their records in dependency court to see, what their history is, and wondering, there's new judges all the time in dependency court. What interaction does your office have maybe in educating the judges, or kind of saying, here's a trend we've seen when certain decisions were made in your courtroom, and this is how ultimately this kid ended up?
We have seen from the beginning of this program, for example, the CARE program, and when we started about 10 years ago, when we first started and we had social workers, I mean, I think that the bench was sort of skeptical about, who are these people? Why are you bringing them on? What can they do for me that I'm already making these decisions?
Right.
I don't need necessarily. What can they do?
Right.
And I think that over the years, we have seen judges now appreciating this information a lot more. Because what we tell our social workers is that we want, when, for example, if they testify, that they give their independent professional judgment as to what should be the proper outcome
Right.
in this particular case. And I think that we have seen a definite trend where the bench has come to appreciate this input and appreciate our expansive role in terms of what we do and why we do it. And that support comes, I think, from the presiding judge, Judge Nash. He appreciates, I think, what we do, and from some of the other bench officers. So we've seen a positive shift. It's not I don't want to give the idea that it's an avalanche. It's not, but it's been encouraging. We also have a court, what we call 300 WIC court, Welfare and Institutions Court in Pasadena, and there we are collaborating with, we're focusing on kids who are coming from the dependency system, who are, they come from the dependency system and they're now in the delinquency court, and it's a unique collaboration where we are working with different agencies to provide better outcomes for these kids that come from both worlds, the dependency and delinquency system. And it's a successful model. We have our lawyers in there, we have social workers in there in the Pasadena court, working with the courts and all of these different agencies, the district attorney's office is there. It's been positive. And once again, Judge Christina Hill at Eastlake with the Juvenile Mental Health Court, she totally understands the whole issue of psychosocial trauma and the need for treatment and services. So we have judges around the county who understand the issues, and I tend to be the
Right.
optimist. So
Just seems like sometimes the new judges get put at independence in court, sort of their paying their dues.
yeah, well, we still have some of that, and that certainly needs to turn around. But generally, I think that the judges understand the whole issue. There are exceptions.
Good. Well, we appreciate what you're doing.
Thank you very much.
Absolutely. And actually, it's unique, and because of that, it's very impressive. Unfortunately, it's not catching on in other places as well as you're doing here in Los Angeles. Also, I'd just like to make sure that everybody understands that Judge Nash, who's in charge of the juvenile courts in LA County, he's touted as being a very unique individual throughout the country when it comes to his courts being open and responsible and making sure that these kinds of programs are in fact fortified. When I met him recently, I didn't realize he thanked me for the Shift Gardenas funds as well, and I didn't even have that in mind. But when he described to me what they were doing, that's exactly what I wanted the money to be utilized for as well. So when you get a chance to see Judge Nash, please thank him for me.
Actually, he was part of the delegation that 10 years ago, that when we went to Sacramento to visit, he was part of our delegation, so he totally understands.
Yeah, he must have listened when we were talking, because he interpreted it very, very, very well. Also, if you could please tell your public defender, Mr. Michael Judge, thank him so much for all the wonderful work that he's empowering all of you to do. And again, I think it's important that the public defenders, not only in Los Angeles but throughout the state and the country, they need to put their foot forward, and they need to be in those committees, and they need to be on those panels, and they need to be on those working groups, be it governors or what have you. you need to be present, because in my ignorance, I did not require you to be present when it came to the Shift Cárdenas grants and funds throughout the state of California. If I had it all to do all over again, that's one of the things that I would definitely make sure that you are required to be in the room so that you can give your perspective and you can be represented. So thank you for, without being required to be there, thank you for being there. And please encourage your colleagues to do the same. And your name?
Shalon Joseph, Deputy Public Defender.
And what do you do for the Public Defender's Office?
I am a resource attorney that's assigned to the Division of Juvenile Justice Unit, which is a unit that does conditions of condition monitoring, mental health advocacy, and education advocacy for youth who are incarcerated to the Division of Juvenile Justice, which is California's youth prison. And it is a post-disposition program. We do have 2 lawyers and 1 social worker assigned. 90% of our time is spent within the institutions throughout the state of California, monitoring the conditions of confinement, because DJJ is currently under a consent decree for lack of rehabilitation provided to youth within their custody. Our main focus is to file motions with the court, Welfare and Institution Code 779 motions, to bring youth back to the county if the Division of Juvenile Justice is not providing youth with adequate treatment, care, education, mental health needs.
Okay. Thank you as well.
Thank
you
you.
very much.
Thank
Any
you
other
very
questions?
Oh, thank you.
All right. Okay, with that, we'll move to adopt that motion. We don't have any public comment cards on that item. I didn't see any public comment cards turned in, so public comment on that item number 2 is open and closed. Thank you very much. We now go back to item number 1.
Oh,
We went straight to 2. Yeah.
Item 1, communication from the mayor, the city controller, and the city attorney relative to a follow-up audit of the city's comprehensive strategy for fighting gang violence.
Good afternoon.
Good afternoon. Good afternoon. My name is Mildred Lopez with the Mayor's Office of Gang Reduction and Youth Development. I'm here to report on behalf of the Mayor's Office in response to the follow-up audit of the blueprint for a comprehensive citywide anti-gang strategy, which was dated February 26th of 2009. First, I'd like to thank Controller Chick and her staff for the time and work that was put into the creation of this report and the audit. We really look to this document to help guide us in the development of our office's goals and objectives. On March 31st of this year, we submitted a formal response to the Controller's audit. So I'm going to provide just a quick overview of our accomplishments since our office's inception back in July 2008, and then just to highlight some key points in our response to the Controller's report. First, I'd like to recognize that the Controller's report noted that our office made considerable progress in implementing the new anti-gang strategy. So of the 122 specific recommendations outlined in the blueprint, we met 113 of those recommendations. So that's a 93% implementation rate in 8 months. In addition to providing a response to the Controller's audit, we provided a status report for activities starting in July 1st, 2008 to December 31st, 2008. So we highlighted several accomplishments, including the successful closeout of the LA Bridges 1 gang prevention contracts, the release of 3 separate RFPs to support gang prevention, intervention services in our grid zones and non-grid zones, as well as the release of the RFP for the evaluation component. And we've launched our Summer Night Lights program in 8 parks throughout the city, which contributed to a 17% overall decrease in gang-related violent crime. We also unveiled our vision document, Healing Our Neighborhoods. We launched our new Violence Interruption and Crisis Response Protocol, which calls for increased partnerships between gang intervention workers and LAPD and greater accountability from our gang intervention workers. Lastly, we executed a memorandum of understanding with the Community Development Department with the primary goal of referring ex-gang members, ex-offenders to employment and education resources. So we established 500 slots for this population. We also highlighted upcoming projects, including the Safe Passages program which is a partnership between the Commission on Children, Youth, and Their Families, LAPD, LAUSD, and the City Attorney's Office, and our launch of our Gang Intervention Academy, which we're looking to create a singular training academy for gang intervention specialists. And this is a partnership with various partners, including Advancement Project, A Better LA, Maximum Force, Cal State Los Angeles, Pat Brown Institute. So I'll just now refer to the various items in our response. The blueprint asked for the creation of a single office to coordinate anti-gang services. The blueprint recommended that all of the city's youth development and anti-gang efforts be centralized within one organization, while under the current design, our office only administers programs specific to our 12 grid zones and non-grid zones. Although we agree that all of the city's youth development programs, coordination of all of the programs is important, we believe that to be the most effective in accomplishing the goals of reducing the unacceptably high levels of gang violence and gang membership, the grid office must at this time focus on creating and administering programs that expressly address those goals.
Now, hold on that note, the centralization of these services at one location, I think what, correct me if I'm wrong, you're expressing that your interpretation of this blueprint idea is that one location for services means like one office.
Our interpretation was that all youth development and gang prevention intervention programs be housed under the mayor's grid office. We're speaking specifically to not the other programs that are currently administered under the Community Development Department. So the FDNs, the Family Development Networks, the NAPs, the Neighborhood Action Programs, the Youth Opportunity Movements in Watts, Boyle Heights, and Pacoima. We're referring to those programs that we, at this point, we can't accept under our office.
Okay. So you're not talking about the actual sites out there in the community?
No, we're talking about the oversight and administration of these programs within our office.
Okay.
So our priority has been to develop a comprehensive system of carefully defined programs designed to address the special circumstances of gangs and to capture and focus the city's scarce resources to the youth and neighborhoods with the greatest risk and greatest need. So therefore, we've identified these 12 grid zones and these non-grid zone areas to focus scarce resources. The audit also recognized that CDD had developed plans to redesign their own youth and family services programs to address concerns noted in the blueprint. So they did note that with appropriate coordination and oversight that these alternatives could be successful. And if I'm correct, CDD is moving towards issuing a massive request for proposals to identify new entities to administer the NAPs, the FDNs, and so forth. Lastly, we've had the opportunity to review CDD's program redesign and have committed to review their plan and progress in 3 years to determine whether it's appropriate for CDD to retain youth development programs or whether complete consolidation is appropriate and will be pursued. The second item speaks to the coordination of anti-gang efforts through the grid cabinet and building partnerships with entities such as LAUSD, LA County, and other local agencies. So the audit suggests that the grid cabinet should act as a policy-making body and that it should establish a strategic plan. So while we understand and accept many of the observations in the audit about the role of the grid cabinet, we believe that the cabinet can recommend the adoption of particular policies, but it is the mayor and the council who are charged with setting policy for the city. And given the existing focus of the grid office and the vast amount of work that needs to be done to enhance collaboration and coordination, we do not agree that it is appropriate at this time for the grid cabinet to expand its role to oversee general youth development strategy and program policy, as was suggested in the audit.
And,
However,
and why is that?
Can I just finish? Okay. However, we do agree that the grid cabinet should better articulate the roles and responsibilities of participants and to create a mechanism to track action items. Although we do understand, the urgency to create a collaborative body. We do have partnerships with LAUSD and the county currently on the grid cabinet to enhance coordination efforts. And we're also working with them on the Safe Passages program, Summer Night Lights, and the county's 3 gang reduction strategy pilot sites in Harbor Gateway, Pacoima, and Florence Firestone. Item number 3, gang intervention agencies and reentry services. So the audit noted that our office addressed a number of the controller's concerns concerning intervention workers, specifically with respect to background checks, training, and supervision. We are taking steps to monitor the intervention contractors to provide adequate training through our Gang Intervention Training Academy, which we hope will launch in June of this year, and supervision on an ongoing basis. So we will directly oversee fingerprint and background checks with all gang intervention staff through the city's personnel department. We will provide gang intervention workers with gear and BlackBerries, which will provide them greater access to LAPD and require random drug testing.
You can access that information.
In addition, we've been meeting with representatives of the probation department to identify individuals with prior gang affiliation present in our zones and our non-grid zones who will soon be released from probation facilities. The audit suggests that formal memorandums of understanding or other formal working relationships be established between the grid office and the probation department and other appropriate county agencies regarding reentry and other services. So we agree with this recommendation and we will pursue it. Item number 4 calls for the establishment of rigorous performance measures and evaluations of city and contracted programs. The controller expressed the view that specific performance objectives and the entire evaluation piece should have been worked out at the front end before new contracts were awarded. We respectfully disagree. And given the urgency of the problem, we decided that we needed to proceed in the most efficient and effective way to marshal as many resources as possible, as quickly as possible, to those targeted neighborhoods in need. So in doing so, moreover, the office was guided and the service providers are being held to express and specific performance objectives. These objectives have not only been set out in the relevant RFPs and contracts, they have also been developed with the assistance of many of the very same subject matter experts who on a pro bono basis developed the scope of work for the evaluation RFP and participated in the selection of the evaluation provider. Now, we completed the request for proposals for the evaluation component, and we've identified the Urban Institute and Harder & Company to assure that the data being collected and submitted by the service providers will be consistent with the requirements of the evaluation. We will not only be training providers, we will be working closely with service providers to ensure that data is entered correctly and consistently. We're currently in the process of submitting a proposal to our city's Information Technology Department to support the creation and development of a comprehensive web-based case management system for both our gang prevention and intervention providers. While we know that all city programs relating to youth development should be effective and evaluated for their efficacy, we currently don't have the personnel nor the financial resources to evaluate programs run or administered elsewhere in the city, as suggested by the audit. Finally, the audit requests that we reassess the gang reduction zone model. We intend to use the results of the evaluation to inform policymakers in the city about how well both the model is adopted and how well the intervention contractors are performing. So we will proactively reassess the grid zone model and the ratio of prevention and intervention services. And that concludes my presentation. Thank you.
The last statement you made about we will proactively evaluate the grid zones, et cetera, the model. Who's we?
Our evaluation component. So it's Urban Institute and Harder & Company. So we've asked, we just held a meeting with our contractors, Urban Institute and Harder & Company, to provide us with an annual report card to ensure that the agencies are performing, that they're targeting, the right kids and right young adults for service provision. And internally, we have our own monitors to ensure that the agencies are meeting their contractual obligations.
Okay. But what you just described is monitoring and evaluation and feedback on the various elements that make up what is the model, right?
Yes, yes.
But the
So-
model was something that was designed, proposed, and being implemented by the mayor's office. So what do you think the mechanism is going to be to evaluate the model as a whole, including the new team in the mayor's office?
Well, the Urban Institute is currently working with our office to develop their scope of work, which my understanding is that it's going to be both a process and an outcome evaluation. So it's going to evaluate how well we implement the model. So it's going to look at the creation of our advisory committees, what role they had in making sure that, we meet the specific goals and objectives set forth in our strategic plans. Also, the needs assessment, how the needs assessment helped in the development of the grid zones. The specific data that was collected to initially identify our grid zone. So not only the LAPD crime statistics, but also the other demographic information we use to help us identify those grid zones. So it's reevaluating the entire process from the needs assessment to the identification of the zones, to the identification of our prevention and intervention providers, to the implementation of the comprehensive delivery system, so prevention, intervention, reentry, and suppression, and how that collaboration looks, and service provision to the youth and families. So it's an evaluation of the entire model and its components, as well as how well did these agencies serve these kids? Did we really make an impact in the lives of these kids and these young adults? So there's two separate evaluations.
Okay, but I'm still wondering, see, there's a common thread in everything you just described. In this holistic, you're going to have sub-evaluations and then more broad evaluations, and then I would imagine one final report or what have you, or holistic reporting. But there's a common thread in all of that. This system is set up by the mayor's team, being overseen by the mayor's team, and every element of evaluation that you just described, be it voluntarily or paid or what have you, they're handpicked by the mayor's process. So how can they honestly be critical of in this case, it's not a department, how can they be critical, honestly critical, about the hand that feeds them, the hand that picked them? There's an inherent flaw in this, and the reason why I say that is because, correct me if I'm wrong, as far as we can tell, there's no other city or county in the United States that's actually doing what we're doing here in Los Angeles, city of Los Angeles, correct?
Correct.
So it's not like there's a backdrop of experiences that we could say, now this is a successful model that they did in Houston, or this is a great one that they did in Chicago, or a bad one, or what have you. So here we are charting new ground, a new system, a new way of trying to address this very important issue. And yet, as it stands right now, the mayor's team is in charge of everything you just described, and yet we expect that there's going to be full-fledged, honest responses and evaluation toward this unique system and new system we have?
Well, that completely makes sense to me. So I understand your concern.
You mean the question makes sense, but it doesn't
Yeah.
mean that you or I or anybody has figured out
Yeah,
how to get past that.
My understanding was that the controller's office really, through this audit and through hiring subject matter experts to serve on their audit, would serve that function in terms
Yeah,
of.
but the last time we spent $500,000 for the controller to do some kind of evaluation or something, it wasn't worth much.
No,
And
no.
I was the one who pushed the motion, and I was the one who convinced my colleagues and the chairman of the budget committee to give the controller $500,000, and it wasn't worth much. So for us to put that much emphasis and value on a life and death paradigm that we're trying to change in this city worries me a little bit. Again, you're not the controller's office. You're not the one that imposes how we're going to evaluate, but everything you described was all of these elements that come together via the responsibility that the mayor's office has. And there's nothing wrong with everything you just described, because it's all in line with the responsibilities that were given to the mayor's office, right? But we still don't have that mechanism for that holistic, honest evaluation of looking ourselves, including me and the council and the mayor and his team and the providers and everybody else, to look ourselves in the mirror and say, okay, it's a moment of truth.
Well, I know Jeff isn't here, but I know we'd be more than happy to sit with your office, the controller's office, to identify what that independent body or oversight looks like. I mean, we are working with, you know, our evaluator, UI, and the Harder and Company to identify, you know, what factors we need to look at in terms of developing that evaluation.
Mm-hmm.
So, again, my understanding was that the controller's office would provide oversight of this entire process, including the evaluation process.
Okay. Hold on a second in the interest of time. I think we have some staff in the room. I'm thinking that item 3 we could handle in about 5 minutes. So we're going to go to item 3 real quick and then come back to where we're at right now. That way some people don't have to wait around much longer just to take care of 5 minutes of business. So we're going to hold item 1 in the committee, and then we're going to go to item 3 real quick, and then we'll be back in hopefully in about 5 minutes on right where we were. Okay? All right?
Item 3, communication from the mayor and CAO report relative to the acceptance of the 2008 congressionally mandated award for the Foothill Community Law Enforcement Recovery CLEAR program.
Okay. Yes.
Good afternoon. Melissa Fleming with the CAO. The Mayor's Office of Homeland Security and Public Safety is requesting authority to accept a 2008 congressionally mandated award of about $179,000 from the Department of Justice. The grants are a program period effective September 1st through 2008 through February 28, 2010, and will be used to support the operation of the CLEAR site in the Foothill Pacoima Gang Reduction Youth Development Zone. I do want to note when this item was heard in Public Safety Committee, we requested a technical correction to recommendation 4C to change the salary account for receipt of grant funds for the city attorney from 1020 to 1010, and the Public Safety Committee approved that technical correction for this item.
Okay. One of my questions is, when do we anticipate that the county will be accepting the authority to accept the remaining allocation of the grant?
Julie Crane from the Mayor's Office. The county is not receiving funds from this grant.
Oh, no? Okay.
It's for the city attorney only.
Oh, okay. So there's no tied-in grants or anything like that tied into the county?
Not
That's correct. This item particularly was a specific earmark provided to the city directly for city attorney salaries.
Okay. All right, good. Yeah, because all I see is city attorney salaries here. Okay. All right. Anything else? Okay. Do we have any public comment cards?
Yes, sir.
Item number 3, no public comment cards on item number 3. Anybody want to come forward on item number 3? Okay. Seeing and hearing none. Okay. So with that, the committee, public comment is closed. The committee will concur with the recommendation of the Public Safety Committee to approve the CAO report and recommendations with the technical changes conveyed to this committee. Okay? Thank you. Now we go back to item number 1. So one of the things that I'd like to hopefully clarify is, again, the grid zone concept was developed, and at the very beginning of your statement, Mildred, you mentioned that that concept was developed due to the controller's recommendations in her report. That was the impetus for coming up with the grid zone concept?
No.
Okay.
We wanted to focus on those areas that were most impacted by gang crime and violence, and also recognizing that we needed to redirect scarce resources into communities that were most in need. The controller's blueprint came after we identified the zones.
Okay. So where did the impetus for the grid zone concept come from?
It came from mainly from looking at past studies, and I can't name those. One of them being the Boyle Heights program which was federally funded by OJJDP, the gang reduction program, which focused in on specific reporting districts, LAPD reporting districts, and communities that were impacted by by levels of high crime and violence, high gang crime and violence.
So it was crime statistics that were the main driver in determining what the grid zone geographic area should be.
That was the initial. Initially, we looked at those, and then as we put together the needs assessments, we identified other demographic information. So we looked at high school dropout rates, educational attainment, number of kids that were receiving services from the Department of Child and Family Services. We looked at kids on probation. We looked at income levels, and so forth. So those things.
So it was beyond crime statistics.
Yes.
It was crime statistics, income levels, other
Before we
factors.
started, yes, with gang crime levels, yes, and then went from there.
Okay. One of the things, and how often does the mayor's team feel it's necessary to conduct needs assessments on the system as a whole, to look back and say, are we going in the right direction? Do we have enough time and data to start saying this is the right way, or we got to go in a different direction?
My recollection is that we agreed to do them on an annual basis. I have to go back though to confirm that.
Okay, I think those are different things, but for example, the motion that I wrote to move this particular responsibility into the mayor's office was quarterly reporting to the council, but that's not evaluation, that's reporting.
The blueprint, I recall, requested a needs assessment, a citywide needs assessment of all youth development programs, which we said we can't do. And then we agreed that we would reassess the communities every 3 years.
Was it 3 or 5?
I believe it was 3 to 5. I don't know. I have to get back to you on that, but
Okay.
3 to 5.
Georgia, you got any recollection of?
Yeah, mine was 3 to 5, and the controller's audit ultimately determined that it should probably be every 3 years, mainly because
I want to know the mainly because part.
mainly because there would be shifts in crime patterns and populations. Within the city, it could not be, things do not stay stagnant.
Mhm.
And what is often a hot spot, once successfully served, problems tend to migrate and change. So needs assessments would constantly change to follow. A yearly needs assessments would be too soon. 5 years might be too long. So 3 was determined as a reasonable period of time to do the needs assessments.
And we stated 5 years in our response.
Yeah, that's what I thought. 5 years
5
in your
years.
response. Okay. 5 years is a long time. 5 years is a long time. Again, this is life and death, ladies and gentlemen. I'm not saying you don't understand that, but a summer on this issue is a long time. And for some families, one night is a long time. if something's going on outside their home. Got people sleeping in bathtubs and stuff. 5 years is a long time. Georgia, can you give a little bit of your perspective on the dialogue that we've had so far on this item?
I want it read into the record, of course, that I was a subject matter expert retained by the controller on this audit. However, I was a subject matter.
So you're going to take credit for the whole thing?
Well, no. And in fact, and my input was limited to areas in which I had expertise.
Okay.
However, probably my biggest area of expertise is evaluation, but I was forced to recuse myself because of a conflict of interest on that section, because I did in fact participate in the pro bono group, the applied research group that Deputy Mayor Carr drew upon for expertise in framing performance objectives. I was also the person who drafted the evaluation section of the controller's original blueprint plan. So because of those two things, I was in a conflict of interest. So nothing that was stated about the evaluation drew upon any of my subject matter expertise. I did, however, make suggestions and recommendations in the 5 other areas. Now I want to pull back from that and give you the 5-minute view of the landscape, because I'm in a unique position in that I have watched the unfolding of this entire gang reduction strategy since the days when Martin Ludlow chaired this committee prior to your taking over.
Yeah, he dragged me into it.
Yes, he
and
did.
then he left.
So, and at that time, and I think it's very important for me to kind of haul out my institutional memory on this one, because Martin Ludlow was passionately convinced that there should be a department, and he felt that it should be a freestanding city department.
He shared that with me as well.
So I did do work for Council Member Ludlow. I was part of a group that testified in front of the ad hoc committee, and I too became a very strong believer in the idea of a department, a freestanding department. And then there were a number of developments, not the least of which was that counterterrorism received the lion's share of attention and funding. And you struggled against this, and if I may be so bold, Mildred, while she worked under the former deputy mayor, Marisa, struggled against this mightily. Marisa hired me to be a gang policy advisor to the mayor. And working very closely with Mildred, we did work on this. At the same time, I was retained as a subject matter expert by Constance Rice and the Advancement Project to work on the initial proposal for gang reduction in the city of Los Angeles. And the Advancement Project produced an absolutely beautiful document that if we had only had all the money to fund
Sure.
what they suggested we
Didn't
should
have
do,
millions, it had billions.
we would all be happy,
Yeah.
okay? And we'd all be very busy right now. Unfortunately, that's not the way things went. And so I worked, in follow-up from Martin Ludlow, and along with you overseeing it as the chair of the ad hoc committee, I worked assiduously on that proposal. I saw what happened in terms of the idealistic ideas that were in that proposal that could not possibly be funded or implemented, and then I went to work in the mayor's office. And quite candidly, Mildred and I faced an uphill struggle in drafting an idea that was based upon the Spergel model. And the Spergel model was held in very high esteem, objectively speaking, by OJJDP and by the Department of Justice, and was based on many years of research in the community. It was the best we had in terms of a best practice, and we pushed that through, and that undergirds the current GRYD system. After working together, Deputy Mayor Jeff Carr was hired, and at the same time, the controller began her blueprint plan, as you recall, funded by City Council. And I think we all had very high hopes and expectations for that blueprint plan. Not the least of whom had high hopes and expectations were you, Councilmember Cardenas, and Controller Chick. I will speak very bluntly. Originally, that blueprint plan was to have included plans for a department. But because of budgeting and funding and political concerns, that was eventually came to fruition as not a department, but an entity that was housed within the mayor's office, that it was held out hope that that would eventually, over years and with available funding, evolve into a department. The idea with the department, by the way, was to fold in all the youth development programs that were in the CDD, and they too would become part of a department. But that was down the line. And certainly, sadly, at that point in time, nobody foresaw the financial meltdown and what we would be facing fiscally in the city, in the county, and in the state. So Reverend Carr came. He began to build the GRYD program. There was certainly great support, great obstacles. Needs assessments for the 12 GRYD zones were completed. I carefully reviewed those needs assessments. They were extremely well done. They were uniform, consistent, excellent. That is noted in the audit. And it is true. Most of what has been demanded by the audit has been fulfilled. I think we are now at the really crucial time that these programs are going to be implemented, and we will see how effectively they are going to work. We are also at a tremendous crossroads. The city is facing its fiscal woes. The mayor is seeking to deal with this budget-wise while reiterating his support for gang reduction. We are also facing an uncertainty in terms of what is going to happen with the crime rate. We have had the crime rate in general and gang-related crime in particular effectively controlled, but we do not know what the future is going to bring. And we are really at a critical juncture in terms of what is going on. You have mentioned the issue of oversight. This has never been far from any of the documents that have been generated, whether by Martin Ludlow, the Advancement Project, or the blueprint authored by the City of Controller. I think we are faced with going to the next steps. The next steps are twofold. Number one, the next step is what Mildred is outlining for us and talking about, that these two prevention and intervention programs are going to be implemented, or they are in the process of being implemented and evaluated. And the other part of this is we are still left with the question of oversight and the ultimate development of this program, either within the mayor's office or to blossom into a freestanding department. So that's kind of the historical overview. And I think that I bring a completely different perspective because I have played a role in each of these initiatives.
Yeah, you have, and I think it's important that I acknowledge the fact that I appreciate your frankness and your honesty, because when I received the controller's report, again, that I convinced my colleagues to give the controller's office the money and pay for it. The controller called me and let me know when she was going to release her report. Like within 24 hours later, all of a sudden she said that I'm going to recommend that it go to the mayor's office. And I was like, we talked a lot about your report, and I welcomed seeing it, Laura, but where'd this come from? And she didn't have much to say other than she'd made up her mind. And then when I received the report and we looked at the report, it seemed as though she baked the cake, but the part about putting it in the mayor's office was all icing. It wasn't in the filling. It wasn't in the middle of it. It was all on the top. And it was all part of her press conference, and it was all part of her, there was more to say about that in the brief outline document and not in the substantive multi-page document. Mm-hmm. So she obviously had did a 90-degree turn very late in her process. And as a matter of fact, I actually talked to the individuals who she hired to actually create the document. And they came to my office. I said, okay. They asked me a bunch of questions. They told me where they were going. They told me what they were looking for, et cetera. And then when she finally had her press conference and released the document, it was completely in a different direction. And I've, to this day, yet to find the substance and the, using her words, blueprint on why she didn't say there's option A, there's option B, and option C. She said there's only one option. It has to go to the mayor's office. And I think the mayor's office is trying to do the best they can with the resources that are afforded to them. But I'm not going to call this an experiment, because it's not an experiment. This is a real live situation. This is real efforts, real energy, real resources, and all of that. Yet at the same time, I've never in my gut been able to get rid of that uneasiness about whether or not the foundation was correct. And the foundation being the announcement by Controller Chick, the advancement project report that had some elements of it that made a lot of sense and were enlightening, but many parts of the advancement project report were things we either already knew or things that really didn't have that much relevancy to what we're trying to do here as a city. Again, I appreciate you shedding your perspective on a lot of the history over the last, what's been like 2.5, 3 years now?
Oh, no, Ludlow was in '02, if you can believe that. So that's when we started.
That's 7 years.
It's been a 7-year march, and we still are underway. And the advancement project report, my recollection is, was in '05 into '06. I mean, we're minimally talking about a 4-year window
Of
here.
this part of this whole.
This whole part that followed Ludlow, and this is not to undercut what you had to do in that interim period where it was, if you'll pardon my using the expression, we were in purgatory, basically, that Martin Ludlow had left while $500,000 had been allocated for a study. And you inherited that and the committee, and then we all sat saying, including, and most of all, it fell on your shoulders, and I remember working with Donna Estacio, and we would say, okay, what's our next step? How are we best going to spend this $500,000? What are we going to do? And it proceeded from there. And I cannot underscore the larger political picture enough to you when I say there was this incredibly strong emphasis on counterterrorism, and you, council member, people like Mildred and myself were kind of in this wilderness of trying to put things together when funding and political will was going in an entirely different direction. And that's not to be disrespectful, not make a value judgment, it's just to describe the mise-en-scene that was occurring at that time. So.
I think that's a very accurate portrayal of what was going on in that time frame. But here we are, and
Right.
we are going to have we have a controller-elect. I think tomorrow, or is it the 25th, 26th?
7th, I thought, but I'm not.
If I believe the newspapers, our current controller will be vacating her position early.
Yes, she's going to Sacramento.
So technically speaking, a lot of this is going to fall on the shoulders of the new controller.
Yes.
Mainly the elected controller-elect, which is Wendy Gruhl.
Yes.
So I'm hoping that she's not on this committee, but I'm hoping that she's fortifying herself with a bit of this history, and I'll definitely make sure that she has any documents that we have under our purview or what have you available to her. I'm sure, I hope and I'm sure that she'll be talking to the mayor's office and their team about what's going on or what have you. Again, she's to no fault of hers, not all council members can be on every committee, but this is where the nuts and bolts of much of this discussion is happening. A little bit happens on the council floor, but most of it happens in this committee. So hopefully the new controller will be able to feel comfortable with all the information we're able to fortify her with. I do have a question, Mildred, on You mentioned blackberries, and when I hear blackberries, and I hear government blackberries, and I hear people that we contract with, like third parties and blackberries or what have you, I think of the, what do you call that, when somebody retrieves government, they can have the demand government information. Freedom of Information Act. Yeah, public records requests, things of that nature. When you mentioned blackberries, whose blackberries were you talking about?
I'm talking about our office assisting with the identification of funding to purchase blackberries for our nonprofit organizations, specifically the street gang outreach workers.
Yeah, but the thing that comes to mind from a legal vantage point is if they were to adhere to responding to the third parties, the not-for-profits in this case, if they were to adhere to a responsibility of having to communicate with the city, and therefore they concluded on their own that they need to get blackberries, I think that would be a different element of potential public access of that information versus blackberries that are purchased in some semblance, be it third-party funding that is gathered by the city or city funding directly that comes out of some kind of city account.
We're actually looking into that now. We do have those same questions that we've asked,
And it's not that anybody has anything to hide. What I don't like is you get a reporter, for example, and they want to do this story, and all of a sudden they request information, and they take something out of context. And by an accident like that, somebody could die. Somebody could interpret that if somebody ratted them out or something like that, because it's not a pretty scene.
We do have those same concerns, and that's why we've asked for the advice of our city attorney.
Exactly. And speaking of the city attorney, for example, when you talk about the blackberries that are in the hands of police officers have a whole other protection of public information. Yeah, sure, you could still get the information from a police officer's BlackBerry, but I can bet you're going to have more blacked out letters and numbers and words in that document that's handed over to that person that requested it, because they have the ability, and rightfully so, to say, this is public safety, this is something that we cannot give to the public. Yes, the document, but if there's 300 words on that page of that document that's turned over, I can bet you 230 of those words are going to be didacted, in other words, blacked out. Yeah. But these third-party providers, they don't have that ability to protect that information like that.
Right. And again, we have those same concerns, and literally an email was sent out to our city attorney yesterday asking, for advice on if we were to, purchase these blackberries for these street gang outreach workers, what does that look like in terms of liability, accountability, and so forth? So we can, report back in terms of, we know that we want them to have
the ability to communicate,
yeah,
correspond, all those kinds of things, sure.
But we still have to meet with our city attorney to answer all those questions. We don't have an answer yet.
Yeah. Well, I'm glad you're doing that because, again, the Freedom of Information Act is very strong in this country, and rightfully so.
Thank God.
Yeah, but at the same time, you could have somebody that inadvertently puts somebody's life at risk, and they don't get it. They just don't understand. And until it happens, or should something like that happen, it's too late.
Right.
They can apologize all they want. I'm sorry, that's not what I meant. But the bottom line is here you have an inadvertent situation that could actually be life-threatening. So that's something that
Okay.
I'm glad you mentioned the blackberries because it's been heavy on my mind, and I wanted to understand which blackberries you were referring to. Okay.
I do want to stress,
Yes.
Councilmember Cardenas, that you are correct, Mildred is correct. The way this is laid out is that the oversight has never been designed to be in the mayor's office, but has been seen as a very important component of this being rolled out. It really has.
Yeah, and the fundamental thing that I don't begrudge this mayor or a mayor or even one of my colleagues or what have you, but there's a certain appropriate difference between when an elected office is handling a program versus a department handling a program. For example, if Department ABC were to be handling something, at any point in time, the elected office of the mayor's office could request that the head of that department come forth and answer specific questions. And they're required to divest that information to the mayor's office. Whether they could do it that moment or say within a week, we will have those questions answered, they can do that. Same thing with the council office or a committee. A department head would have to address and answer those questions appropriately and respectfully, as quickly and as ably as they could. Mm-hmm. But when, like a committee like this is of the council, speaks to you, Mildred, you're not an elected official, but you are part of the mayor's office. Mm-hmm. So therefore, I can request, but I couldn't make you answer the question. And I'm not saying that you do or don't answer the questions when you're asked of this committee, but the bottom line is that is something that is, in my opinion, is very black and white. It's really done as a courtesy when it's elected office to elected office, be it staff to staff, but as long as they're within those offices of elected officials, it is done as a courtesy. And the courtesy is extended 99.9% of the time around here. But the bottom line is when it comes to department, it's not a courtesy, it's a responsibility. And there is no, I'm sorry, I can't tell you. I'm sorry, we're not going to answer that question. It just can't happen. Just can't happen. And that's one of the fundamental, and the reason why I bring that up right now is because you just mentioned again, Georgia, is that in the evaluation, especially when you look at the global overall evaluation of how are we moving along with this solution, we stopped short of being able to say, okay, flip over all the cards, let's see what we got. An elected office, and I don't even say the mayor's office, an elected office is not required to participate to that nth degree. And that's a fundamental dilemma. I wouldn't even call it a problem. It's a fundamental dilemma that we've created with the system that we have right now. No offense, but it's a dilemma.
I just want to say, I think initially when we looked at the blueprint, in all fairness to our program managers, our staff, we've worked diligently the last 8 months to really follow this blueprint.
Mm-hmm.
And by that I mean we were instructed by the controller's office, it was recommended that we create a single office, which we did. We established a new procurement process in terms of identifying new agencies. We're doing things differently in terms of accountability and making sure that we're putting resources into the communities that are most in need. Mm-hmm. So I just think, in all fairness to my staff and, to the group, I mean, we've been working really hard. And as you can see, we've implemented 93% of what was asked of us. So I think, that deserves recognition as well, that, we've followed the roadmap that the controller's office created for us, for the city. But we can't do it all, obviously. We can't, we started with LA Bridges, and I think we successfully closed out those agencies, those programs, and transitioned into this new model. But if the plan is going to change, whether that be an instruction by your office, the controller's office, I don't know. I think we should be recognized for the work that we've done the last since July of 2007 in implementing the city's vision of what this office should be and where we should be dedicating resources and staff and so forth.
Yeah, well, the council moved the motion to move it into the mayor's office. corresponding with the mayor's office throughout that process. In addition to that, the council and the mayor agreed budgetarily how much resources can and shall be dedicated to this, and that was done in last year's, or our current budget, which was approved last year. You've never heard me say publicly or privately that the team in the mayor's office isn't working hard or diligently or what have you. Everything you just said, I take it at face value and as fact, and I think that the efforts and how far you've gotten reflects that kind of energy and effort. Yet at the same time, the evaluations will come and need to come. The structure needs to be tested, the tires kicked, or what have you. And we all have to be ready to make changes or take a different tact as we learn and grow. Because again, we can't even read a book about history, about how another community did it, where they can say, we did the same thing, and these were the mistakes we made. Don't do that. We learn from our mistakes, and these are the things that worked out very well, and this is why. We can't even do that in this situation. So every day that we go by with these grid zones, it is, again, I will never call it an experiment because it's real life. It's not a test. It's the real thing. Every day that goes by, we're charting new waters. Every day that goes by, we're doing something that has never been done before. And therefore, these evaluations are even more critical, more important. And with all due respect, the controller's office is going to play a role in some of that evaluation. But then again, there's all those sub-evaluations that are happening within the system in and of itself. Those are critical as well. But yet we're still missing an element of how we pull it all together with an evaluation that we can all stand there and allow ourselves to both be criticized, praised in those evaluations and say, okay, now what do we do tomorrow? What changes are we going to make based on what we've learned?
We are going to do that. So, as I said earlier, I mean, we're working with the Urban Institute and Harder and Company to develop an evaluation where they can collect data. They can design an evaluation where we're able to collect data on a real-time basis, and then they come back to us, whether that's in an annual report, to tell us this is where you're failing, this is where you're not making progress, this is where the model needs to change. So
they're gonna do that and submit it as an unfettered evaluation and just turn it in? Who are they gonna turn it into?
Well, obviously, they're going to turn it into our office because they report.
You
to us.
contracted them.
Yeah, exactly. But keep in mind, I mean, that's why I want to go back to the controller's office because, you know, our understanding was the controller's office was supposed to be an independent body that would conduct audits as they would do regular audits of departments of our office in terms of what progress we were making in you know, implementing this blueprint for a comprehensive citywide anti-gang strategy. Which, again, if that changes or if it's updated, then of course we'll evaluate it and we'll follow it. But that's why I want to go back to they gave us a blueprint, we followed it to the best of our ability, and this is where we're at now. So we understood that the controller's office would conduct these audits every 6 months.
Mm-hmm. That's right, twice a year.
Yeah.
Yeah, that's what the blueprint says.
Yes, so every 6 months. So we gave them everything under the sun.
Okay, you keep looking at me though. This is making me really uncomfortable.
So the controller, we gave them everything under the sun. It was like over 170 items that we needed to follow up on. So we welcomed the controller's office. We said, audit our office, audit our, you know, programs, whatever it may be. And we gave them everything and anything that they asked for. So we're still on board, whether that's Controller Chick or Controller Gruhl. As long as they tell us what, you know, their expectations are moving forward, then we're more than happy to comply with what they ask for.
And your relationship with them on that note is information. They ask you for XYZ,
Well-
give it to them, et cetera.
Well, that was what, the system that they had put forth.
Yeah.
So-
Mhm.
Yeah, so, in determining whether we were successful in implementing the blueprint, yeah, we needed to provide them with the support documentation.
Okay. Well, one of my colleagues had a question, and that is, if you could elaborate on the type of safe passages programs you're exploring with LAUSD.
We are going to be ready in the next couple of weeks to present our citywide safe passages plan.
Okay.
So I don't have an exact date, but in the next few weeks.
And I'm assuming there's hopefully going to be a strong correlation between the grid zones and the safe passages recommendations.
I believe so.
I mean, they're on the natural, they're the hot spots, and
I believe so. I haven't seen the plan, to be honest
Okay.
with you. But I know our office has been working closely with the school district, the Commission on Children, Youth, and their Families, the partnership schools in identifying creating our safe passages plan.
okay, thank you.
And I'm sorry, Georgia, you're not the controller's office.
No, I feel like, yeah, you keep saying these things, and I do, I really.
Oh, you want the interim job?
Yeah. No.
The,
No, I will continue to be the subject matter expert, and
Yes.
Okay.
happy to do it.
okay, is there anybody here for public comment on item number 1? Nobody coming forward on item number 1 for public comment, therefore, public comment is closed on item number 1, and this is a report. Any action required on this? What's that? Okay, so we'll note and file this report. And with that, we open it up for general public comment. It is now time for general public comment of this committee. Anybody here for general public comment? Seeing and hearing none, general public comment is closed. This committee is now adjourned. Thank you all very much.
Thank you. She provided a good history. Absolutely. Historical perspective of where